This is Colin O'Keefe for LXBN TV, and my guest today is Peter Vogel, attorney at Gardier Winsewell and author on the Vogel Internet Information Technology and E-Discovery blog. Today we're discussing a very popular lawsuit, one that was covered in the New York Times recently, revolving around Twitter followers and who owns them. A mobile phone site called Phonedog is suing one of their former employers for his Twitter followers that he amassed over his time at the company. First off, Peter, can you walk us through exactly what happened here and why does Phonedog claim they own these followers?
Well, Noah Kravitz, who is the defendant in this lawsuit and a former employee of Phonedog, posted tweets when he was employed by Phonedog, ostensibly, I assume, to really help the business, which apparently it did. He had about 17,000 followers, which is pretty significant, I think, for not the highest profile business in the world. And so when he left their employ about 8 or 9 months ago, he made a deal with Phonedog that he could take their Twitter name with him. And in return, what he did was he agreed that he would periodically post some tweets so that they could help promote Phonedog. And that went on for about 8 months. Actually, he changed the name from the Phonedog Noah name to Noah Kravitz. So he wasn't even continuing to use Phonedog. So they brought this lawsuit. So Phonedog brought this lawsuit against him, claiming during this 8-month period that he owed $2.50 for all the 17,000 followers, claiming essentially that it was a customer list. And I think this is a pretty novel legal claim that I don't think I've seen before.
And, you know, Phonedog obviously claiming it as a customer list. Normally, in situations like this, these customer lists have to be secret. How can Phonedog overcome that fact in a lawsuit like this?
Well, I think that's a great challenge for them because normally customer lists are protected by some kind of agreement between the employees and the employer to the point where it says the employee, whenever they leave the employee, they won't take that information, they won't use it to their advantage at another employer's. And in order to have the veil of protection associated with that in all the states in the U.S., it requires some kind of trade secret protection. And I think 43 states apply the Uniform Trade Secret Act, and a number of states like Texas do not. But in every one of the states, in order for a customer list to be protected that way, it has to be a secret. Well, to me, it's hardly a secret if this information isn't even at Phonedog. It is actually the Twitter on Twitter's computers. And I looked at the terms of service on Twitter, and nowhere did they obligate themselves to protect by secrecy anything that's out there. Not to mention the fact that who the followers may be could publicly be visited by almost anybody that looks at that account.
Exactly. It's a very unique situation. And lastly, you know, we have the two parties with Phonedog and then their former employee, but then there's, of course, the third party, which is Twitter itself. You know, in the past, Twitter has been very, very reluctant to intervene in any type of situation, you know, in terms of taking down accounts and that type of thing. Is it possible, can Twitter possibly be forced to take any action in this type of lawsuit?
Well, that's an interesting question, and I don't think there's a simple answer to that either. I think it's going to rely on what exactly Phonedog can prove as to their real ownership in the names of the followers and who they may be in their Twitter accounts. I think it's going to be a very difficult case for them to win, but of course we don't know what the evidence is here. This is just, you know, based on the original complaint filed in federal court, although they filed it probably in one of the best court venues to get an idea, since they filed it in the Northern District of California. And one of the advantages of being in court there is that the judges are confronted with technology disputes all the time. It's the home of Twitter and many other companies in Silicon Valley. So we may get some interesting rulings on this, but it's just hard to imagine that Twitter is going to want to, you know, be helpful on this. I think they're going to be forced to provide certain information. They may do it under protective order, so it's not publicly available. So I think this is something that we all want to stay tuned on because it potentially could have an impact on social media very broadly.
It'll be very interesting to watch play out. I know Twitter in the past has been very very reluctant to get involved in things like this. But like you said, this is going to be a case many people are going to be looking to in the future. Various employers, both outside of publishing and otherwise. Well, once again, that's Peter Vogel of Gardier Winn Sewell and the Vogel Internet Information Technology and E-Discovery blog. For more on this case, be sure to check out Peter's blog, of course, VogelITLawblog.com, and of course, LXBN.lexblog.com. Thanks, Peter.
Thanks, Colin. Nice to visit with you.